but I think that, I mean, maybe the common link which came with all these presentations and talks was the issue of legislation. For example, Baudouin said that he in the abstract that he chose the topic of paternity because there is hardly any legislation about it. The state has not legislated about paternity. It's basically left it to the discretion of judges. For example, I know better the Egyptian case in which the only intervention of the legislator in the issue of paternity was the fixing a maximal period of pregnancy and curtailing the jurisdiction of the courts in cases in which the child was born after longer periods than the maximal period of pregnancy. So, I mean, my question, and I think that it comes up in all the talks, is can we figure out from all the case studies any logic or any mechanism why the state in certain cases chooses to intervene, or in other cases leaves it to the discretion of the judges, and when it is left to the discretion of the judges, what about the issue of uniformity of the legal system, and how it is possible to to be answerable to all the many normativities that are in stake. For example, Professor Cesare, you mentioned the issue of Turkey. You haven't talked about Turkey in terms of time. You not have, but I mean, we have an Islamic government in Turkey, but we haven't seen, if I'm right, we haven't seen any Islamic legislation in Turkey. So how does it work? In the case of Palestine, we see that we are waiting for years to a Palestinian family law in Palestine. What is the difficulty here? Is it to reconciliate divergent social, cultural, gender perception with Western perceptions of legal rights and gender equality? What is going on here? And also in the case of inheritance laws of non-Muslim communities, we see that in certain countries we see an intervention, while other countries leave it or claims the dominance of Islamic inheritance law on non-Christian communities. So, I mean, the issue of generalization here, can we generalize about this whole process of this main question? So I think that we can open the floor now.
Yeah, perhaps we can just collect. Actually, we are very short in time because we have a limited time for our for the lunch, room for our lunch. So perhaps we'll collect a couple of questions and quick answers, and I can do it.
I have a short question, clarification for Irene. You speak about the third level. So you have Sharia court, first level, then appeal, and then supreme.
Yeah.
Because Sheikh Tamimi tried to do this, and the constitutional court say it is unconstitutional, so they established it with this decree, or it was with this decree?
Before.
Before.
Yes.
Okay, when do you know the year? Because Sharia court constitutional court says that it is illegal, unconstitutional. But maybe they establish
there's this tension between the two parts of it.
And then they establish it after. Okay.
Thank you. Also to Irene. So first, to clarify, the Constitution actually says that international norms are above the domestic law. Does that mean that it's but it's not a system, it's not a regime, it's not a monistic regime that automatically domesticates or, okay. But specifically for CEDAW, I was actually on the committee when Palestine reported. Of course, I could not take part in the actual dialogue with them, but it was very interesting. It was the first treaty body, the first international convention that they joined in Geneva, and reported. And they got quite harsh critique, focused on family law issue, and it was also one of the follow-up points, meaning that 2 years after their initial report, they had to report back, and I see some interesting information that they did start a process, both with respect to what they call protection of the family, which is actually domestic violence legislation, and with respect to personal laws regulating personal and civil status, reviewing in 2018, and I won't go into details, but it seems that there is an ongoing process of legislating. So I just wonder.
I also wanted to just ask a technical question. When we think about law in this context, which is a not fully sovereign nation that writes law in theory, I wonder how descriptive this is really going to be of what the facts on the ground look like when and if sovereignty is established. All of us sort of live in some tension between the law that we want in our heads and the law that we want with our feet on the ground. And it's easy to design a perfect legal system in theory. It's sometimes harder to implement. I just sort of wonder how you can really write a legal code. Whether writing legal code abstractly is any sort of reflection of the tensions in the real world.
Last question.
I wonder, and this is to all of you, if you can try to generalize what is a better mechanism for changing law or changing practice, is international norms or top-down method, or maybe the opposite, maybe a change is better when it is come down, bottom up, and if it is come from the internal language of the own culture. And another question is if you can compare inheritance law versus marriage and divorce. For example, in Jewish law, it is quite amazing that we don't act as the original inheritance law, and in terms of that the daughters it's a practice issue inherent, and it doesn't really matter to people. So everyone understands that we can't continue with official law. In divorce law, at least in Judaism, there is all the time back and forth, and a lot of objection to deep change, and I wonder if the same phenomenon is also in Islamic and Christianity.
So let's do it 2 minutes for each of you by order of presentation.
I will be as short in my answers as I was in the presentation. Regarding Ron's question, actually there are bits and pieces of legislation regarding the issue of paternal affiliation, especially in Indonesia and in Morocco, not that much in Egypt. In Egypt, it's also because the personal status code has never been fully written, and so we we are still in a fragmented situation. The reason why the personal status code was not written is in itself linked to your question. You know, this is a sensitive issue, and for many reasons, legislatures were reluctant to fully codify this issue, the question. In the case of Morocco, in the case of Egypt, of Indonesia, it's a little bit different. There are bits and pieces of regulations and legislations on this issue, but the way it is formulated leaves room for maneuver and interpretation, and this is why we are interested in this topic, because it is not only what the legislature said about this issue, but it is about how judges interpret it. And we see very different and conflicting interpretations of judges. In the case of Indonesia, there is a conflict between the Supreme Court and the Constitutional Court. The Constitutional Court ruling in favor of equality, and the Supreme Court ruling in favor of a strict application of the Compilasi Hukum Islam, which is the non-compelling personal status code in Indonesia. In Morocco, the situation is a little bit different. Appellate and cassation or Supreme Court judges were quite conservative in their interpretation of the Mudawanat al-Usra, the personal status code. But at the same time, recently, we had a royal discourse saying that the interests of the child should be at the center of the forthcoming reform of personal status. So we have another situation of attrition, so kind of attrition between different authorities. There was another question, I'm not sure it was addressed to me, but you know, I think that the gap between theory and practice in the case of Palestine also reflects the gap or the delusive character of the Palestinian state. There are many attempts at creating something ideal, perhaps, but the fact is that you know, on the ground there is no real authority able to implement anything concretely and practically having an effect in the lives of people.
I want to address your point. Actually, what I'm suggesting is there is a way to generalize, and if we accept to take the nation as a foundational modern political community for everything, including illness, including degrees of happiness, we don't look at that, but there is a whole anthropology of what happened to men in this particular mankind, in this particular community. So what I show in my work is that if we take this premise, we see that all Muslim countries have been built on two precepts that have been applied across the board with different levels. The first one is you are a Muslim, so you are national. And even if you are a member of a minority, by default, you are a Muslim in the public space. There is this example of a Copt saying, I'm Copt by religion and Muslim by nation. Cannot be said in another way than that. And it does have influence on the legislative system. And the second thing is that Islam, Islamic law has been reduced and reframed as some kind of Islamic prescription applying to the person, which was not, which is also a very modern approach, meaning the person as the individual and the receptacle of rights. This is not what religious communities are or were about. So once you combine both, you can see what happened, why there is no Islamic legislation under the AKP. First, because Kemal Atatürk did the job. You are Turkish and Muslim, so that's you. Second, because generation of Turks have absorbed this idea of laicity, of laicity, and nobody, even the Islamists, will reclaim Sharia as state law because there is no family law based on Sharia. So if you look at the type of contestation everywhere, it's on family law. To my knowledge, the Islamists are not looking to reinvent economy and other or transaction law. They are very happy with the secularization of that. They are focusing on the already pre-existing presence of Islam in the institutional system, which is family law. That's why the women body has become such a site of contestation. So already here you have a few elements of generalization. The second is indeed about religious freedom and acceptation of religious and social pluralism. So that's the kind of thing you can generalize.
Yes, I try to answer. I find it difficult to generalize because I think in each of the countries which I know, which I've had done research on, the combination of political power, the Sharia establishment, the civil society, and the discussion in the public sphere is different, and such is the influence. So with regard to Palestine, perhaps to say something about the gap of theory and practice, yes, there was a discussion in the Palestinian society also, saying we should leave everything until we have our state, and others said no, we have to start immediately. But on the ground since 1994 you have a kind of state. I mean, go to Ramallah and look at the ministries and everything, you see that they are working, they are trying to be a state, even if they are not officially recognized. So they do their best, but of course the political power, and this is perhaps the problem, is not very strong. And the Sharia establishment at the moment, I think, is very strong. So when Len Belshman did her research in the 1995 years, she was thinking that the women's organization would have the power to push through their drafts for Palestinian family law. But it didn't get to this point. And now we have the problem of no parliament, no elections, and so on and so forth. The split between Fatah and Hamas, which is a very big problem. Yes, the state is in a way weak, but on the other hand, also Abbas is strong because he implemented now this decree and gave Mahmoud al-Habash, a very powerful position in which he can exert his opinions as ta'mimat, as regulations, and get through. This is quite interesting because he's very conservative. The older one, Yusuf East, the former one, he was very much in favor of talking about women's rights and trying to give women their rights. And the ta'mimat were not only on the khula, but also, for example, on the inheritance law, which we just heard. So giving women the time of at least 4 weeks after the deceased, after the death, so they could not be put under immediate pressure and could think about. So these regulations exist as ta'mimat. And with regard to the process, no, it's not monistic. The Constitutional Court said it should be above, but of course Mahmoud al-Habash said Sharia is above everything, and this is the problem, the tension and the discussion in it. There are many discussions, the muwa'amat, they call it, harmonization of the law, and there are different, we can talk about bilaterally. Yes, but the law on family violence, for example, it exists since several years, but it's not put into practice. CEDAW has not been put into the official gazette, not so far. So this is the situation on the ground.
Yes, with respect to the question regarding international law and whether international law is an effective pressure mechanism, with respect to the family laws applied by Christian communities, I would definitely say no. So I've looked at the CEDAW documents of various countries in the region, including Egypt, Syria, Palestine, Jordan, and what is remarkable is that the family laws of Christian communities, or in Morocco, for example, the Jewish community, are almost absent from the CEDAW debate. And I think that is the case because in the case of the laws applied by Christian communities, the state is not the lawmaker, so the state would argue that this is a case of non-state law, so there cannot be any change implemented by the state, or at least that is the pretext. And this is why this is not really discussed on the international level. And members of the church courts would say that there is no pressure by international law to reform the law, whereas, for example, the Sharia courts, they feel the pressure quite strongly, and there were quite a few Sharia judges who pointed out to me in Jordan that this is a case of an international bias, so there's such a close focus on the reforming the Islamic family law, but there's no regard for the family laws applied by Christian communities, and they saw this as an indicator for the international system being biased against Islamic law. But I think it has more to do with how the law is organized. So this regional organization instead of national organization, and simply the fact that the state does not make these laws, but these laws are issued by the communities themselves. Thank you.
Thank you. Okay.